Straight ahead on Law and Crime Daily.
We have a suspect in custody, and justice will be served.
Authorities announce an arrest in the shocking shooting of 2 sheriff's deputies. It turns out they already had their man locked up.
Plus, one of the officers charged with killing George Floyd says new evidence could vindicate him.
And closing arguments in the case of a man accused of cooking his mother's head on the stove over Thanksgiving weekend.
Nobody else had a reason to do this.
Law and Crime Daily covers court cases from coast to coast.
Welcome, everybody, to Law and Crime Daily. I'm Aaron Keller, along with Brian Buckmeyer and Terry Austin. As usual, let's begin in Tennessee right off the top with closing arguments in the murder trial of 32-year-old Joel Guy Jr. He's accused of stabbing his parents to death on Thanksgiving weekend. Testimony revealed that the parents were making plans to retire and were going to stop supporting the defendant financially. They'd been paying for his apartment. Authorities found a notebook riddled with what prosecutors say were plans by the defendant to kill his parents and dismember their bodies, including using chemicals. One of the passages seen here saying, "Get rid of bodies inside house, my DNA already there, flush chunks down toilet, not garbage disposal, and get plastic sheeting for disposal process." And then there's this police body camera footage recorded after a coworker called 911 to report something suspicious may have happened to the victims. Authorities say they found the head of the defendant's mother cooking inside the pot on the stove. Upstairs, several officers found severed hands in a gruesome and disgusting scene. Let's head straight to Terry Austin with the state's closing argument. Terry?
Aaron, prosecutors say the defendant committed these murders beyond any reasonable doubt and reminded the jury of what the state called Guy's book of premeditation.
The same book that has his DNA on it. Essentially, the writings, what they do is they corroborate everything that's out in the crime scene. So everything he set out to do, he did. Get rid of the bodies inside of the house. The proof has shown that he did that, ladies and gentlemen, or at least attempted to. Get carving knives to make small pieces. Get knives because they're quiet. Get multiple of them. Get plastic sheeting for the disposal process. Get bleach denature proteins. Get plastic bin for denaturation process. Turn heat up to 90 to melt fingerprints and dry everything. Turn heater up as high as it goes to speed decomposition. Okay, well, we know what he wants to decompose. The disarticulated, the brutalized bodies of his parents that are in an acidic-based fluid.
Prosecutors say they've proven that Joel Guy Jr. intentionally killed his mother and father.
So with regard to Joel Guy Sr., we know that he was executed in the exercise room with apparent signs of struggle. The blood patterns on the walls, there's clearly a struggle in this room. Going down the hallway, where Investigator McCord and Ballard were able to see the severed hands in a praying-like position of Joel Guy Sr. She was lured upstairs, up the stairwell, and brutally attacked. Blood present on the way up the stairs, likely the result of Joel Guy Jr. bringing his mother's decapitated head down the stairwell, ultimately putting it in a stock pot and boiling it for days before it's ultimately discovered.
Well, Terry, the top charge here is first-degree murder, so the state has to prove the killing was premeditated and intentional. How did the state do in the closings as to the law and to the style of the argument?
Aaron, as far as I was concerned, this is a bases-loaded home run out of the park. They had an opening statement which was detailed and organized. They had witnesses which were introduced to establish certain pieces of evidence, and they did that. And they had a closing with a PowerPoint that showed all of the relevant information. So absolutely, the prosecution did its job, and they did it well.
Boy, a home run, bases loaded, that's got to drive fear into the mind of the public defender. Brian Buckmeyer, walk us through some of the defense closing argument here.
The defense argued that the testimony from the relatives presented a portrait of a happy family the holiday weekend the killings occurred. In other words, they say the defendant is not the killer.
That weekend, Joel Guy was outgoing, friendly, and happy in a way Michelle Tyler had never seen him before. Outgoing, friendly, and happy. That was not a man about to commit a homicide. Outgoing, friendly, and happy. You saw it in the picture from the front porch. Smiling, happy. That's who Joel Guy was that weekend. He was not someone planning on committing a murder. His father was stabbed at least 41 times, his mother at least 32 times. That is anger, that is rage, that is not happy and outgoing. We heard family testimony that they planned to cut him off financially at Christmas. This was not Christmas. This was not when that was going to occur. That's why we have to look at every fact to see if this adds up.
The defense also argued the authorities failed to test evidence for DNA, including the mother's clothes. The defense also backtracked on the source of the defendant's injuries, which at one point where they agreed occurred during a fight between the defendant and his parents.
Clearly, we know at some point he hurt his hand, but that doesn't tell us when or how he hurt his hand. The fact he's getting medicine for his hand does not tell us anything about the homicide. And again, on the DNA, they get to pick and choose what they tested. Kim Lowe decided she just wasn't going to test some things that she decided weren't relevant. For example, the kitchen glove. I said, what about the kitchen glove in the master bathroom? Do you cook in the master bathroom? Do you do dishes in the master bathroom? And that's where the bodies were? Don't need to test that. That's not going to tell us anything at all.
Okay, Brian, I was surprised about what the defense said there because they stipulated that the hand was injured in some kind of altercation with the parents. And then they said, we don't know why or how it happened. Can we reconcile that at all?
I think that's a defense attorney attempting to slide in some amount of reasonable doubt. But like a mosquito trying to bite an elephant, I don't think the prosecution was really worried about that because they had so much more evidence that they can point towards his guilt.
So it's possible the prosecutor could have wedged an objection of some sort in there or at least argued against it, but they didn't because there's so much else going on here. So the so-called happy family photo argument, what about all the testimony about rancor over money?
Yeah, I don't really like that argument. I don't like many of the defense attorney's arguments here, but of course I don't have the file in front of me. I don't know what he's constrained to argue with, but there just seems to be so many missed opportunities by the defense that he could have woven in some amount of reasonable doubt here.
Well, the state has the burden of proof, of course, in a case like this, any criminal case, so the state gets the last word. During a powerful rebuttal, prosecutors pointed to a possible motive and to means.
She paid for the tubs that she and her husband disintegrated in. She worked all those years at Jacob Engineering to put him up, to keep him in his lifelong whatever program he's in at LSU. She wasn't going to cut him off. Oh my goodness. She gave him everything he wanted. And then she had the nerve to tell him that they retired and needed a break.
And still ahead here on Law and Crime Daily, the forensics evidence in the Joel Guy Jr. case, which allowed the prosecutor to make some of those claims. Also later on, can evidence of a police officer's good deeds in the past end with his acquittal in the alleged murder of George Floyd? We discuss the law behind an interesting tactical move. Back now to forensic evidence in the murder case against Joel Guy Jr., who stands accused of killing his parents. A medical examiner testified that Joel Guy Sr.'s body was so heavily damaged that the expert could only give an approximation of his injuries.
Even some of the arms, Mr. Guy's arms were down to bone, and some of the bone had begun to dissolve. There could have been more wounds. So the numbers of wounds that I give is an at least number, meaning so much of the tissue was gone, so much of the skin was gone, that it's impossible for me to give an exact counting. And on the skin of his back, he had what I identified as 34 sharp force injuries. Associated with these stab wounds, I identified injuries to the liver, lungs, and kidneys, and ribs. This diagram demonstrates that virtually all the skin had been dissolved away on Mr. Guy's, the front of his torso, and that his arms were disarticulated and his legs were disarticulated and his head was skeletonized.
Does this indicate that Mr. Guy was assaulted both from the front and the back, your findings?
Yes.
Lisa Guy's head, of course, was found in a pot on the kitchen stove, and the rest of her body parts were in her bathroom. Investigators had to piece them together to perform her autopsy.
Her head was completely severed from her body. Her arms were disarticulated at the shoulders, and her legs were disarticulated at the knees. So in comparison to Mr. Guy, who had his legs disarticulated at the hips, Mrs. Guy's legs were at the knee, so her thighs were still intact. Her thighs were still attached onto her body, but her head was completely severed and her arms were completely severed. Miss Guy had multiple sharp force injuries on her back. She had at least 25, and again, I'm having to do a little bit of a hedge because of the degree to which the remains were altered. They included injuries to the heart, so the right ventricle or the right side of her heart, the aorta in her abdomen, both lungs were injured, the left kidney, the liver. She also had 5 stab wounds that were relatively superficial on her buttock as well.
This is horrible to listen to, Terry, but look, this is a real-life trial. The state's going for murder one here. Did the state meet its burden of proof in this case, you think?
Absolutely, Aaron. I think the prosecution successfully demonstrated beyond a reasonable doubt, beyond any doubt, that Joel Jr. murdered his parents. He dismembered their bodies. There was a plethora of evidence. There was DNA. There were receipts. There was witness testimony. And the most incriminating evidence was the fact that this notebook outlined the plan and the motive for the murder.
And remember, Terry, the jury is seeing a lot more than we're showing here.
Absolutely. Thank goodness we're not seeing it. I don't think I could stand it because the head in the pot is the worst part. And my understanding is they saw some of that at least.
Yeah, it's really bad here. Now, Brian, tactically, was it smart for the defendant not to take the witness stand in his own defense here?
Probably the smartest thing he's done in the last 4 years, because the potential for impeachment. If you just look at alone, he testified in the hearing and he gave one version as to how he got the injuries, but ended up flipping, and there was a stipulation that he actually got those injuries from an altercation with his parents. That impeachment alone would have buried him, and any other one that would have come up would have definitely hurt his case.
A skilled prosecutor would have basically forced him to go bit by bit through everything they thought he did, and he would have been stuck trying to answer it. Well, when we come back here on Law and Crime Daily, I look forward to key questions which may be answered by the release of grand jury recordings in the police shooting of Breonna Taylor. And we're also taking a look at new court papers which outline a possible defense for one of the Minneapolis officers accused of murdering George Floyd. More analysis is right after this.
I'm not a resistor, man. I'm not.
We've all seen that disturbing body camera footage of George Floyd struggling with Minneapolis police officers before he died in custody. But we're now learning more about the defense for those officers going to trial for playing an alleged role in George Floyd's alleged murder. Court papers filed this week reveal that one of the officers charged is trying to introduce body camera video of an unrelated good deed. Thomas Lane's attorneys say they have a recording of Lane helping a homeless black man one night after the man's electric wheelchair failed. Lane proceeded to assist the man and ultimately walked, pushing the wheelchair through a snow, ice, rain mixture in the January winter cold to the police precinct, where the gentleman could rest inside a warm building while his motorized wheelchair charged. This specific instance of conduct of Lane's character will be strong circumstantial evidence that Lane did not, with criminal intent, assist in the murder of George Floyd. Brian, from a legal perspective, let's first key in on those words, criminal intent. What do they mean and why are they important here?
So I apologize for laughing because I read this motion and it was quite laughable. When we're talking about criminal intent, it is broad, but we're really talking about the mens rea, the mental standpoint that a person would have to commit a crime or not. So what they're trying to say is, by doing this good deed for this handicapped African-American male, he obviously could not have had the intent to kill George Floyd, a very separate and distinct act.
So, Terry, generally prosecutors can't use character evidence to try to prove a defendant is a bad person and therefore more likely to have committed the crime charged. But defendants can raise evidence of their own character, but if they do so, it's usually dangerous. Explain why.
Well, it is dangerous, Aaron, and this is a prosecutor's dream come true. If the defense opens the door by introducing good character evidence, well, the prosecution can walk right through that door and demonstrate bad character evidence of any sort whatsoever for the most part. So while there doesn't seem to be any prior complaints against Lane, they can look at any other bad deeds that he has done and bring that into evidence. So it wasn't a good idea as far as I'm concerned.
Brian Buckmeyer, when you said this was laughable, take us inside the opinions inside your head. Let me just put it that way.
All right, so there's two ways you can argue this. You have to show that the two incidences are so similar that you can evince some sort of evidence that they have a mindset for peacefulness. Now, think of it logically. What the defense is saying here is that, yeah, one time I held down a black man and killed him with the aid of another officer, but on another time I helped a black person who was handicapped get to somewhere warm. There's no similarities there. It's not close enough, and it's ridiculous on its face.
Look, it's highly possible the judge might turn around and say this is just not even relevant. It doesn't even pass the bar of relevance to get into a case like this. We'll wait and see how the ruling turns out. And when we come back, two sheriff's deputies on the West Coast are shot in their own patrol car. Now the authorities say their main suspect is a man already in custody. That and more is right after the break. Grand jury recordings are due to be released by the end of the day on Friday in the police shooting death of Breonna Taylor. Some of the key questions include, did the grand jury consider homicide or manslaughter charges regarding Breonna Taylor's death? How did the prosecutors explain the law of self-defense? And how much of the recordings won't be released due to privacy concerns? Attorney Ben Crump represents Breonna Taylor's family. He spoke with me recently about his hopes as more information is due to become public. Do you fear that the authorities could use the redactions to hide anything that you need to know as part of your own investigation, or that the public needs to know to make sense of this?
And that's always a concern. Transparency is the key. The problem is that there is mistrust between law enforcement and minority communities. And the solution is transparency plus accountability equals trust. Think about all the ways they tried to cover up this case and sweep it under the rug, where they said that there was no forced entry, even though we know they busted in Breonna's front door to gain entry, and they said that there were no injuries, even though Breonna Taylor's body was mutilated with 6 bullets while she was in her underwear in the sanctity of her own apartment, killed by the police.
And let's head now to Los Angeles, where a suspect is under arrest for allegedly ambushing 2 deputies. The Los Angeles County Sheriff says 36-year-old Deontay Lee Murray walked up to the deputies last month and shot them while they were sitting in their patrol vehicle. Investigators believe the suspect drove past the deputies multiple times that night. Both deputies are at home recovering. The sheriff says Murray has a long criminal history and is affiliated with gangs. He was arrested 2 weeks ago for a separate carjacking, which ended after a 9-hour standoff. At the time, the sheriff's office said Murray was not a suspect in the shooting of the deputies. Now they say there's evidence linking him to both cases.
The forensic firearms report was completed and published by the Sheriff's Department Crime Lab. This compared ballistic evidence from the scene of the attempted murder on the deputies to the pistol which was discarded by suspect Murray during the pursuit. It was determined through ballistic comparison that the pistol recovered was the pistol used to shoot the Transit Services deputies. Additionally, that pistol was conclusively linked through forensic testing to suspect Deontay Murray. The firearm in evidence is described as an 80%er, a ghost gun, a .40 caliber pistol loaded with 8 rounds, 5 rounds short of its full capacity. There were 5 rounds fired at the deputies.
The suspect pleaded not guilty to the attempted murder of law enforcement officers and to additional charges in the carjacking case. The Los Angeles District Attorney says the defendant faces up to life in prison if a jury convicts him.
Well, at this point, we've charged. We have deliberately chosen the charges that we believe we can prove As this case progresses, you know, in any case of this nature, we expect more witnesses maybe will come forward, maybe more information. And if, in fact, we find evidence to substantiate that this was for the benefit of a gang, then we would amend the charges. What we did here is charge what we had.
Terry, in order to get the level of conviction they seek here in California, you have to have specific intent, you have to have a deliberate act, and you have to have malice aforethought. Can you walk us through the law a little bit there?
So, Aaron, you know, the prosecution has to show that the defendant actually tried to kill the victim here, but for reasons not intended by the defendant, for reasons beyond his control, the resulting crime didn't occur. So basically, had the officers not assisted each other, had police not come to help them, they would have died. So the intent is there, but the actual event did not occur.
Brian, I got to key in on something that the sheriff said there. He used the phrase ballistics conclusive ballistics. Ballistics and weapons usually aren't conclusive from an evidence standpoint. That's evidence that's open to a lot of attack, right?
Exactly. If we're talking about is a .40 caliber gun and a .40 caliber bullet, that could be any number of guns that fire that bullet. What we really want to look at is the striations of those bullets. Oftentimes people will say those striations leave what would be like a fingerprint on that. The video we see is not ID quality. This is not a case that is definitely proven beyond a reasonable doubt. There is some reasonable doubt as to identification, and that could be a problem down the road. I only hope they got the right person, because he's going to feel a lot of the weight of the law.
Certainly. And thanks for joining us on Law and Crime Daily, everybody. Appreciate the insight. Thank you for being here. We will see you next time for our discussions.
I'm Dan Abrams, and this is the Law and Crime Network.
The only 24/7 network with expert legal analysis and gavel-to-gavel live trial coverage. Watch the Law and Crime Network today.